Here we go with another episode of Ask the Lawyer. This time we're going to ask about what you should do if you're in a car wreck while you're driving for work. And here to answer our questions is attorney Sarah Stottlemyer with Stottlemyer Associates in Atlanta, Georgia. Sarah, thank you for making some time for us today.
Thank you so much for having me again.
All right, so we have a scenario. I'm driving for my job. I'm injured in a wreck. Is that going to be a different case than if I'm just injured in an accident while driving my personal vehicle on, not on company time? Walk us through that a little bit.
It will be. So if you are on company time, which means you're in the course and scope of your employment for your employer, you're being paid, you're doing something work related, that will fall under workers' compensation.
So is that is it more than one case? It's just a workers' comp case at that point?
Well, that depends on who really caused the accident. So if someone else, say, rear-ends you while you're driving on company time, then you might also have a third-party liability claim, which would just be a motor vehicle accident. Their insurance would then be responsible as well. So you could have actually two claims going at the exact same time.
Is there any difference if I'm driving my personal vehicle on company time as opposed to driving a company vehicle on company time?
There's not. The only additional kind of safeguard is that would remove any sort of argument of whether or not you actually were in the course and scope of your employment at the time of the accident. If you are driving a company vehicle, provided you're not on either a lunch break or some sort of substantial deviation from the normal job duties, then you would absolutely be covered under workers' comp, whether or not you're in your personal vehicle or in an employer-provided vehicle. However, if you're in an employer-provided vehicle, it just makes it easier to make the argument that you were, in fact, in the course and scope of your employment.
That makes sense. All right, so we've determined it's workers' comp. What happens next? Do I need to get an attorney? Do I handle it through my company and through HR? What do I do next?
You want to notify somebody immediately, your supervisor or your HR. Notifying a coworker doesn't really count, so you want to make sure that you notify. In Georgia, there's a 30-day time limit where you need to provide notice to your employer. Speaking to an attorney as quickly as possible is fairly important, to put it mildly, because you're going to be given a choice of doctors to select from. I know we've covered that in some of the other videos that we've done. But the panel of physicians that you get to choose who treats you is vitally important, because you don't know what really any of those doctors likely, where an attorney would know which doctors are more pro-insurance company or pro-injured worker.
And so I need to find an attorney who has experience in workers' comp cases, I would assume.
Yes, it's a very small niche in the law, and it's very case specific for each injured worker that comes through. A lot of your general attorneys that either just do personal injury, motor vehicle accidents, trucking cases, employment discrimination cases, they're not going to know all of the nuances that the workers' comp system kind of operates within.
Because with workers' comp, are we talking, is it different if I'm a government employee using a government vehicle? Does that change things?
That doesn't necessarily change things at all. So if you're working, for example, the state of Georgia, so in Georgia, we have the Department of Administrative Services is the kind of government insured system that you have. There's only some differences in the sense that that then falls under what's called a managed care organization. So there's a larger group of physicians that you can choose from. And unfortunately, Georgia is not currently settling any of their DOAS cases due to budgetary constraints. So it's not always hugely favorable to be a government worker and suffer a work-related injury, but it still falls under all the same requirements, and the same laws govern government employees as well.
What if I'm a contract employee? Does that change things? Say I'm being contract like a subcontractor for a construction job, and I'm driving for that job. Does that change things?
So no, it doesn't. However, if your direct employer, say, for example, has 3 or less employees, then they're not going to be required to have workers' comp. Sometimes you can make an argument where if your employer should have had workers' comp, but they didn't. Say if they're a subcontractor for a larger builder, for example, you could make the argument, it's called the statutory employer argument, where that builder actually has to cover their subs. So you could kind of go up the chain of command on, we like to say who has the bigger pockets or who has the more insurance. You go up to them, sure. And then you can make the argument that they would have to provide workers' comp if you are injured on the job. It doesn't always work. And it's kind of a tough battle to do, but that's the argument that you would make if you're a subcontractor and your employer should have had workers' comp but didn't.
So when we talk about just general automobile accidents with injury and that sort of thing, we always say take a lot of pictures, gather evidence at the scene when witnesses. Does the same thing still apply in this sort of case?
Absolutely, especially if you're also trying to do a third-party claim for a motor vehicle accident. So if you're hit from behind, say you're driving for your employer and you get rear-ended, and it's clearly not your fault, the other party's ticketed, then you would also have, again, like I said earlier, the third-party liability claim against that driver. However, you would want to get a workers' comp insurance company involved as quickly as possible if it was in the course and scope of your employment, because most of the time when you have a third-party liability case, you are treating on a lien, right, until the settlement of your case comes through. If you have a workers' compensation claim, then you end up getting that medical treatment paid for under workers' comp. So that money won't come out of your settlement for your PI claim. So it's very important if you have two claims that you start immediately on the workers' comp claim so you can start getting that medical treatment already paid for.
And I know we've talked about this in the past, Sarah, but I think it's worth reiterating. So this whole workers' comp process, it seems to me, it seems extremely complicated, and making sure you meet all the deadlines and the proper proof. It's not the kind of thing someone should try to do on their own, correct?
No, I wouldn't recommend trying to do it on our own. Unfortunately, there's probably somewhere around 70% of injured workers that do handle workers' comp claims on their own. The goal of the Workers' Comp Act is to simply, if you get hurt on the job, to pay for the medical treatment, to pay for a portion of your lost wages and get you back to work. However, a lot of times you're unable to do the job that you were able to do prior to your work-related injury. In those cases, you absolutely want to have an attorney because they're going to make sure that they get the largest value for your claim possible.
And especially if the initial claim is denied, then the process gets even more crucial to have somebody to help you through it, correct?
Absolutely. You don't want to go to a hearing in front of an administrative law judge without an attorney on your side. The insurance company has many, many attorneys, and they pay them a lot of money to defend their cases. So you would want to hire someone as quickly as possible to help you.
Do you find there are cases maybe sometimes where employers say, oh, don't worry about that, you don't need that, we'll handle it? Does that happen, and is that something you should be careful about?
That does happen. If your employer is saying, we'll pay you under the table, we'll pay for all of your out-of-pocket expenses. I've seen that happen in a lot of my cases, and inevitably it always ends up where it ends up being too much money for the employer towards the end when they start getting MRI bills and things. That's even prior to any sort of surgery being recommended. And then you're past the notice deadline. You can make the argument that the employer knew. Obviously, they were paying for all of that medical treatment themselves kind of under the table. But I would recommend not doing that ever because, again, I've never seen it where the employer has covered those expenses and not later then said, well, this is too much money, we can't do this anymore. So I would recommend getting an attorney involved as fast as possible. Now,
you say as fast as possible. Oh, in these kind of situations, maybe your life is turned upside down. Maybe you can't work. What if you're thinking, I'm not sure I can afford Sarah to help me through this process?
Well, there's no cost for workers' comp attorneys in Georgia, and I'm fairly certain in all states. You get a free consultation immediately, and then we can help advise you on how to move forward on your case. Also, we don't get paid unless you win. So if there's a settlement in your case, after we've worked on it for a year or two, I've had cases that have been 8 months. I have cases that I've had for 9 years.
Wow.
Where I haven't earned anything on yet. And that's our job, is to help usher people through the system. Again, in Georgia, it's statutorily set where for all workers' comp attorneys, it's 25% of any attorney's fees are 25% of any recovery that we may get for you. So that's not going to come until much later. So there's nothing out of pocket that you have to pay to us to meet with us or to get advice from us.
Well, that is such great information, Sarah, and it's great that there's somebody like you out there to help people at a time when I'm sure they just don't even know where to turn. And so to have somebody to help them like yourself, that's great. Thank you for answering our questions today.
Thanks so much for having me.
There we go. That's going to do it for this episode of Ask the Lawyer. My guest has been attorney Sarah Stottlemyer of Atlanta. If you want the best information or you're ready to choose a lawyer that lawyers choose, make sure to go to askthelawyer.com first. Also, please take a second to like, share, and subscribe to our YouTube channel by clicking below. Thanks for watching. I'm Rob Rosenthal with AskTheLawyers.com.